Hello, everybody. I'm Rick Morgan, a partner at Husch Blackwell, and I want to welcome you to the third session of our Navigating Mold and Contaminated Building seminar series. And today we're going to be discussing defense and plaintiff strategies. In my work, I primarily represent private companies in high stakes, high exposure toxic tort litigation, including exposures resulting in serious injury and death. I routinely handle plaintiff class action matters around the country, and I've appeared in trial in courthouses in more than 20 states, from Texas to Minnesota, from Massachusetts to California. I also represent insurers in toxic tort cases, and I have substantial experience defending mold litigation matters. Joining me today is my partner, Tina Searing, and Tina's practice focuses primarily on employment litigation, and she represents employers and management in emergency bet the company cases, as well as litigation involving accusations of discrimination, retaliation, harassment, wage and hour violations, and wrongful termination. But in addition to her labor and employment expertise, Tina has significant experience and expertise in toxic tort litigation involving major environmental exposures. These cases often find her in court, and she thrives on the chess match and challenge of motion practice and trial, finding it immensely satisfying to make winning arguments in court. So we look forward to sharing our expertise and answering all the questions you may have about plaintiff and defense strategies. Before we begin, I want to cover a few housekeeping items. At the bottom of your audience console, you're going to see multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them through the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it'll be answered later by email. In our prior sessions, we've done that on a number of occasions. A PDF of the presentation is available in the program materials folder that you can see. Auto-generated closed captions are available for today's program. To turn on the closed caption, click the CC button at the bottom right corner of the media player box. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance will be, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs and to make our presentations more applicable to you. With that, we're going to go ahead and talk about defense and plaintiff strategies. So here we go. Well, I'll be talking about the defense, and Tina will be talking about the plaintiff side. So I'll start off by talking about the defense side. So let's talk about defense strategies. When we look at preparing the defense, we prepare for victory. And victory is defined as making a strong defense effort, making favorable settlements possible, because most of these cases do settle before trial. But we find that if we make decisions to prepare for trial and we look at it through that lens from the beginning, we have better settlements, and we can go ahead and set the bar for success at trial, and plaintiffs' counsel know that we're a serious trial threat. So what we do today can impact cases 2 or 3 years in the future. We have to develop a defense that incorporates the following, and we're going to talk and touch on all these issues in the next few minutes. Strong themes and narratives that exploit the weaknesses of the plaintiff's case and addresses all of the facts, and that includes favorable and unfavorable facts. If we don't address them, the plaintiff certainly will. We have to have a strong corporate story. We have to have strong corporate witnesses, and we have to have a strong played by the rules story. That is, showing that we have policies and procedures in place that we actually follow. And of course, we have to have strong science. For those of you who have been following this series, we talked about science in our last session, and it was very interesting to hear from some of our outside experts about the need for strong science. It's at the key to evaluating the case really does come down to the quality of your documents, the quality of your witnesses, and whether you have policies that are actually being followed and trained on. That's the real key to having success in this arena. So let's talk a little bit then about the steps to get to the strong defense, to leverage favorable settlements. And if we have to go to trial, we've got a great shot at winning at trial. So first, we have to educate the team, both the legal team, the law firm, and our experts about the history of your company, the history of the relationships at the company, the relationships of your organization and your structure. We have to also understand the relationship between your company and any other co-defendants and vendors that you may have. It's going to be very important that we also look at the indemnification relationship you may have with your vendors. And if we have co-defendants in the case, it's very important to try to develop a good working relationship. We're not going to agree on everything or see eye to eye on everything, but it's important that we don't get into a fight with our co-defendants. That only goes to the plaintiffs and the plaintiffs' counsel benefit. They love to see it when co-defendants fight. If we can postpone issues of allocation until later, all the better. It's also important, and this isn't in the slide, it's important to deal with your insurers early, making sure you're providing proper notice and getting buy-in on defense strategies and budget. So we have to then look at the complaint, and Tina will be covering this a little later, about which claims are fact and which are fantasy, and how do we get rid of some of the fantasy allegations out and clean up that complaint and get them dismissed. We then have to develop, and we're going to turn to this now, themes and narratives, and developing the company's story through documents and witnesses. So let's now turn to themes. I want to spend a little bit of time on themes because they're that important. Research in the cognitive and social sciences, as well as some of the neuroscientific research on human beings over the last 25 to 30 years, has highlighted the central role that narratives or stories play in how human beings think. And we know that is just as true in law as it is in real life, okay? So it's very important to understand people think in terms of stories. We're storytelling creatures. If someone asks you about your weekend, you're not going to recite dry facts. You're usually going to tell a story about something that happened over the weekend. You do this almost instinctively. The other thing we know is that human beings can only keep a certain number of ideas in their mind at once, usually about 7. And that's why in the old days, you used to have phone numbers that didn't take up more than 7 numbers, because that's about generally what most people can remember. Why is this important? When we're talking about developing a defense, it's absolutely critical that we understand that our case is about a competing narrative. We're going to be facing the plaintiff's story, the plaintiff's narrative, which is going to be high on emotion, high on junk science, and high on emotional weight. So we need to be able to deal and create a narrative that can counteract that and outweigh that. When people, whether it's a plaintiff's counsel, our opponents, a mediator, an arbitrator, or a jury, if we get to trial, they're always trying to ask themselves what really happened here when they're weighing the different stories of the plaintiffs and the defense. It's absolutely critical that when they're thinking of what really happened here, they're thinking in terms of the themes that we are setting out from the very beginning of the case. From the very start of the case, we start talking in terms of themes, because then people fill in the gaps where the evidence isn't quite clear with the themes. So we want our defense story to be true, believable, and a story that folks will buy into. So let's talk a little bit more then about themes. So themes, again, are tools for telling the case story. You can read the slide, but we try to limit them in number or scope. I talked about that rule of 7. Usually there's 7 general themes that we're going to be talking about, but usually 3 to 5 in any given case. It's also important to have themes because it gives our witnesses a safe harbor. It gives them something to go back to if they get stuck on questions. And again, it's ways that people can remember the case and simplify the case, and making sure that our themes mesh with people's experience, beliefs, and predispositions. They're anchors again, for people understanding the story. But good themes are no substitute for good evidence and good testimony from our witnesses. But inevitably, if you have good themes and they're properly formulated and properly deployed, it leads to better outcomes. It allows us to leverage better settlements and allows us to have success in the event we go to court. Plaintiffs' lawyers will understand the power of a strong thematic defense, and it redounds to our benefit every time. So let's talk about successful defense themes. These are the 7 that we normally look at. There are some cases where we have additional ones, but these are the ones that we normally look to as we're developing our narrative. First, did we provide prompt and appropriate service? Did we do it within the time provided by the policy? If there's a delay, is there a good explanation? Do we have documentation about timely and accurate response times? It shows a culture of caring and commitment to fight the idea that there's a heartless landlord that only cares about profits. We have to make sure that our policies reflect good, solid regulatory guidance, and that we played by the rules and following our policies and procedures, that our people were trained on those policies and procedures. It's absolutely critical to show that we played by the rules. We did what we were supposed to, and it is the kind of policies and procedures we have in place are the ones that are reflected in national standards, and if national standards are referenced in the policies and procedures, that we actually followed them. To me, that's one of the most important things that we have to show in a case. The real science versus emotional science, we covered this in our session in April, but the key thing is that the plaintiffs almost exclusively rely on invalid science, and it's very important for us to have real science and good experts lined up. The idea that we're talking about this plaintiff and this case, we have to prevent other cases, other people's experiences, other people's incidents coming into evidence. We have to be focusing on the plaintiff at hand and the case at hand. This individual's personal situation, this individual's residence, this person's health history. We have to focus on whether there's causation and alternative causation. So the fact is the person is complaining about a mold exposure, showing that that is not really the cause of their problem. And if there is alternative causation, we can go ahead and at least hint at what that might be. We have to be careful. We don't have the burden of proof as the defense, the plaintiffs do, but still showing a no causation is absolutely critical and can lead to successful resolution of the case through motion practice. The idea of personal responsibility is also important. So many times we run into folks who are complaining about mold and then find out that their housekeeping is abysmal. They've got 20 plants that are causing problems in their house. They don't understand how to use a thermostat. So many times we have to look at personal responsibility. We don't want to be attacking the plaintiff unless you get a whole lot of that type of example of misfeasance in the running of your household or a lot of exaggeration. But you certainly want to point at the issues of personal responsibility. And finally, the issue of numbers, not assumptions, to undo speculative damages. I mean, the idea that you have furniture you bought at a flea market, and now you're claiming replacement value with something from a top-end department store or the very best furniture money can buy is not going to work. Looking at those types of things, those types of numbers, and not dealing with assumptions is very important. We want to be careful to make sure that the plaintiffs aren't exaggerating, and again, gently point out when they are. So those are the successful defense themes that we have. So that brings us then to our first poll question. So what's your favorite theme? What theme resonated with you that you think might be the most important? Take a minute and go ahead and vote. Please go ahead and vote. Thank you for voting. Okay, let's go see how the results turned out. There was a lot to read. I appreciate everybody who voted. Looks like the science and the played by the rules were neck and neck, but some people voted for at least one or two people voted for each of them. So that's very helpful. And frankly, that's been my experience too. The science and the played by the rules are really critical. Let's turn now to the foundation of any good defense, which are our documents. All right, here we go. First, it's important to, at the outset, collect documents, and it's going to be critical to have collected the documents that will make or break our defense. Litigation hold, if you're not familiar with it, is a notice to the key players in your organization to hold on to documents relevant to the case, which is usually set out in the litigation hold notice. And those litigation hold notices override, if you have a corporate document retention policy, it overrides that. And it's very important that we gather all of the documents, because if we don't, if we get rid of documents or they disappear, they're potentially helpful to us and we won't have them. And if we don't have a document that we would ordinarily expect to have, there may be a presumption that if we can't produce that document, it would not have been helpful for us. So not collecting documents can be a real challenge and a real problem if we don't do it right. We also then generally interview the key custodians of those documents. And the reason why is so that we understand the documents. It gives us a chance to evaluate our potential witnesses, how they would do in questioning. And it also allows us to check for unofficial files. Many times what we have in the hard drives or the computer system, sometimes are separate paper files, and we want to make sure we look at those. Sometimes those unofficial files can be problematic. Sometimes they can be helpful. We need to know if they exist. We also need to deal with departed employees and look at their records and what they have. If we're not going to be able to have them available to us, we need to know how they were involved, if there are any problems with that. Anymore, emails and texts are fair game in discovery, so it's often you have to be very careful and sensitive about gathering people's texts. And sometimes they have just one device. Preferably they have a separate work device, but if they don't, we have to be very careful about personal information they may have in their phones. We also need to look at vendor files and to take a look at those documents that we may have. All those documents are then put in a database. The attorneys sometimes do it. If we have a vast number of documents, we look for a vendor. And that allows us to also have a place to put our technical literature and making sure that there is a consistent approach to handling complaints and work orders for each plaintiff and each residence. And if we are dealing with multiple cases, multiple claims, hopefully they don't get aggregated in a single action, but we can go see if there's consistency. This allows us to create timelines, which are often very helpful to show we follow the rules. In document collection, there are two goals. We should have the documents to show our story. Do we have a good story of caring and commitment, following the rules, doing things in a timely manner? Do we have a strong story to tell, and do we have witnesses in our custodial interviews who are going to be able to do that story? And again, will we be able to meet our discovery obligations? Do we have a legal obligation to preserve, collect, and produce certain documents? And if we don't, we're going to end up in motion practice, which is usually entirely a waste of money. And we want to make sure that we do everything right the first time. If we think there are going to be multiple claims or multiple cases, doing it right the first time so they don't have to repeat the drill, and that we make sure that we're not getting stuck in expensive motion practice. And again, we're going to be focused on a few things: moisture and mold related issues, whether our company policies and procedures were followed, whether we trained on that, And then the timeliness and effectiveness of our response and repairs to these complaints, especially if remediation is involved. So in the document collection, we're preparing for exhaustive discovery of information and documents. We've talked about the interviews and the document collection or preservation. Again, it's very important to understand that once we go ahead and get through those interviews and the document collection and take a look at that, we're in a position to evaluate the strength of our defense. We really are at that point to start really seriously focusing in on what a reserve should be. Should we be buying this case? Should we be trying this case? And what the budget should look like. And making sure that we've honed that early on in the case. It's also important to identify the hot documents, the good documents, the bad documents, and the ugly documents. And there are always ugly documents. So we, again, have to deal with that, facts both favorable and unfavorable. But key, do we have a good play by the rules story to tell? And are we going to meet our discovery obligations so we avoid needless motion practice? So let's talk a little bit more about witnesses. So in our next session in August, we're going to be talking about witnesses and expert and preparation of company witnesses, fact witnesses, and expert witnesses. But I want to just touch on this subject. It's absolutely critical that we have a company witness, somebody who speaks for the company, speaks for the defense, who is able to show caring and commitment, who's able to show compliance with policies. If we have difficult documents, they can explain them in a believable way, because there are always some troublesome documents, and it can relate our story thematically as well as in detail for what we have in the documents. We have to stress the safety commitment by management and the vendors. And we have to show we are abiding by industry standards and requirements, particularly those referenced in our policies, as far as evaluating issues in the residence and remediating and fixing those issues. We want a person who comes across as if it's their home and their family that's being impacted, putting that human face on the company. So a company witness requires careful selection because they have to testify at deposition and sometimes at trial. We need a significant time commitment to get them ready because we have to make sure that they are ready for the rigors of cross-examination, which can happen in a deposition. And Tia and I have seen many, many times in depositions, it becomes like a cross-examination because many times the plaintiff's lawyer is going to try to settle that case before trial. And we want to get that person early and prepare that person early. It's a significant time commitment. One thing Tina and I have also learned, we want to make sure as a corporate rep who doesn't have snarky texts and emails about plaintiffs. So we want to make sure that that is key. We talked about experts at our last session in March, but it's very important. These are the big three areas that we normally focus on: exposure, industrial hygiene, the idea that what molds or contamination are we dealing with, what testing or visual inspection would be necessary or has been done in evaluating that, and then talking about the success or process of remediation. And these industrial hygienists are going to understand all those rules and regulations, understand your policies, and hopefully be able to connect the dots as an expert that we went ahead and played by the rules. Medical is absolutely critical. We've dealt with experts in the areas of allergies, dermatology, OBGYN, pediatrics, oncologists, where they're claiming mold exposure aggravated some cancer condition. So it's very critical to have the right experts in the medical field to evaluate your case and to be talking about the medical issues. On the building science side, it's critical to have somebody who understands HVAC systems normally and moisture issues and the water, the nature of the water intrusion issues in the building and the steps that were taken to fix and maintain the buildings. We need experts who can teach the jury, teach the mediator. As many times we've had mediations where we bring our experts in to talk to the mediator. During the mediation, we found that to be very effective. We want them to be able to communicate scientific concepts clearly from the position of being an expert in that area, and also to do battle with the junk science that I know Tina's going to be talking about. And most importantly, to withstand cross-examination in their deposition and potentially at trial. So we don't want rookies in there in general. So again, in dealing with the experts, we know that the visual inspection is the gold standard in this area, and making sure that if there's resident test results, that we are dealing with the realities of testing, which oftentimes just give you one snapshot in time and frankly are fraught with a lot of error. And we know, for example, the EPA and a lot of government agencies don't rely on these kind of, especially over-the-counter test results. And again, in the science area, we want to know if the mold or contamination identified is actually connected in the science with the illnesses claimed, and whether there was enough of a dose to provide specific causation of the illnesses claimed. We often find that plaintiffs just cannot establish this, and it gives us a great basis for motion practice to either exclude their experts or to get summary judgment on the other case. If we have an alternative theory as to what is happening here, in other words, we look at their medical records and we see that they had these issues before they moved in, or they've moved out and they continue to have these issues, we can try to come up with alternative theories, remembering though that we don't have the burden of proof. But if we have that, it can be very helpful and effective to present that. So let's talk a little bit now, before I turn it over to Tina, about dealing with damages, and also talking about defeating efforts to aggregate cases and class actions, which we've had some experience in. So when we talk about damages, we often see damages are usually very exaggerated. There's documentation lacking as to the household items claimed. There are issues as to overvaluation of the replacement value, or whether actual household items can be remediated versus replaced. We end up spending a bit of time on those types of issues. We've had cases where mold issues have been blamed for the loss of job or promotional opportunities, and we've had to dig in there. The most common thing, though, are exaggerated physical or medical issues, and we have to collect the medical records from the plaintiffs. And we often find there are pre-existing issues, that there are temporary conditions. In other words, they're claiming allergies in the home. The allergens outside the home are much more significant than what's inside the home, and they don't appear to have problems going around outside. And again, these medical experts are absolutely key to showing that medical issues are exaggerated. And it's important to take all this very seriously, because we have situations where these are very emotional cases. We have plaintiffs who are often very appealing. They look like they appear to be suffering, and they have claims about emotional distress. It's impacted my marriage. It's affected my children's behavior. And again, expert witnesses are key. I have to tell you a quick story. I was on the phone. I was preparing this presentation yesterday, and suddenly I got a phone call, and it was from a woman who had been referred to me by ChatGPT, and she wanted to bring a mold lawsuit against her landlord. And it was a tale of woe. She felt terrible, but her doctors couldn't tie in her mold exposure to her claimed illnesses. Her cat was sick. She had a dirty air filter, and she bought an over-the-counter test that showed 15 colony forming units. I was cracking up because I was literally working on this presentation. I referred her over to a plaintiff's counsel, but it's one of those things. As I was listening to her and her tale of woe, it was very emotionally appealing, but I knew enough to know there wasn't a bit of science or a bit of medical evidence to back her up. She had gone to see one of these mold doctor quacks that we talked about in April, though, and found out she had 10 mycotoxins in her body. So in other words, we still have to deal with the heavy emotion and the junk science because they're very appealing, and we have to combat that. Last thing for me, defeating aggregation and class actions. So it's very important to understand that plaintiffs' lawyers inevitably try to take multiple claims and put them into one case. Why? It's harder to defend where there's smoke, there's fire. So the idea is we get a lot of people complaining about the same thing, and it's going to be much more effective for the plaintiff. It's critical on the defense side to deal with one plaintiff, one residence at the time, and to show that the plaintiff's situation, their medical condition, their unique circumstances of living in the residence differ from everyone else, that their residence has different issues from anybody else. And it's going to be absolutely critical to establish this if we're going to defeat and be successful in severing claims that are in a lawsuit where you've got 5 or 6 different plaintiffs, or where they're seeking a class action. In the materials in front of you, you see exhaust the benefits of Walmart. Basically, what that's saying is you cannot have a class action based on personal injury. Everybody claims they have some sort of allergy-related symptom as a result of mold. That is not enough to get a class. So what we've seen is, and we had this experience a couple of years ago in a case where we were dealing with a number of military families at Fort Belvoir, Virginia, where they were making a nuisance claim. The idea being that it wasn't that it was harmful to health, although it was in there, but it was offensive, obstructed the free use of their property, the mold situation in their homes. And we had 76 declarations. We had to go through and parse through those 76 declarations to defeat the class action, which we did by showing each person's residence situation was unique, each person's physical medical condition was unique, and to show that there was no commonality amongst the plaintiffs bringing that case. And we were successful in defeating the class action, the case of Fisher versus Belvoir Land in the Eastern District of Virginia back in 2024, so just a year ago. So the key thing is that we have methods of going ahead to defeat these class actions. The nuisance is the way to do it to get around the Walmart versus Dukes issue, but we've not seen any further efforts, at least in our cases, to do the class action given the victory we had in the Fisher matter a year or so ago. So it's going to be very important to make sure that we do a dive, not only in our documents, but the plaintiff's documents, to show that, in fact, they don't have much of it. So that's my half-hour ride through defense strategy. And I'm now turning it over to Tina to talk about the plaintiff side.
Thanks, Rick. And I have to say, I'm ready to do the tale of woe, even though I'm a defense attorney. I'm here to take on the plaintiff strategies and their tactics. So we talked a little bit in February, but as a plaintiff's lawyer, you're going to see that they advertise with substandard housing. You see substandard military housing, you can get compensation. You see a lot of advertising for toxic mold, the value of toxic mold. You see the ick factor of that picture of mold on a wall, and what is a toxic mold personal injury lawsuit, and suing your landlord for black mold. Those are all scary words, and that's the tactic they do in terms of their advertising. You hear toxic and black mold, and you think, I'm going to get sick. And you think substandard military housing or substandard housing, that's something where it's bad. And so I want to deal with, talk to a lawyer about that. So the other advertising tactics that they do is class litigation. You'll sometimes now see more and more television advertisements of we're accepting litigation or accepting plaintiffs for a class action against this landlord or this housing development. And so you're seeing more and more television advertisements, but also on personal injury attorneys' web pages. And they're trying to bring in the class because, as Rick noted, on the defense side, you don't want to be having an aggregate group of plaintiffs bringing the action, or you don't want to have a class action because those are bigger cases to deal with from the defense side of things. They're bigger messes to deal with from the defense side. And from the plaintiff side, it's telling a bigger story, which we'll go into on the themes, a bigger story of how bad this landlord is. Look at how many people there are. There's a lot of town hall meetings and grassroots activity that we will see in the plaintiff side of things. You have one plaintiff coming to one personal injury attorney from a multifamily or a multi-resident unit, and they'll come in there and say, I'm experiencing these things. And then the plaintiff's lawyer will say, Let's talk to others. Are there others? And you get the grassroots going. And then the grassroots turn into town halls, often not on your facility, not on your property, but at hotels. And it's all through grassroots communications, text communications, where the other residents or the other tenants of the buildings are communicating, where it's not known to the property manager or to the owner of the property that these meetings are taking place. And the town hall meetings are where they're gathering and getting their plaintiffs and signing them up. And then the letters start coming to you. Then there's the media and social media coverage. And boy, it was fun this morning trying to put on the plaintiff's lawyer hat. I was telling Rick, I put in the word toxic mold into Twitter. And guess how many personal injury attorneys have really great advice for you? So if they're a person or a plaintiff saying, or a tenant saying, I'm experiencing all of this because of my landlord, and I've looked up the word toxic mold, and it looks really bad. And then I go onto Twitter or TikTok, and I can find a personal injury attorney. And one personal injury attorney on TikTok, he has a very long explanation of toxic mold litigation and the 3 things you need. But the 2 most important things are you have a positive home test of mycotoxins, and you have substantial medical records showing this. And if you need a referral to a doctor, we can help. So that's the type of coverage and battles you're dealing with. And so as much education as a property owner and as a community manager and as a building owner as you can do, you're going to be fighting that social media. And social media is huge and rampant. And there's a lot of misinformation on there. And so regardless of how much truthful information you put out there, you're going to be dealing with that. Now, themes. I love how Rick talked about 7 themes from the defense side. We have 6 themes from the plaintiff side. And this is based off of our experience that we've been dealing with. The themes are families and people versus landlords. That's the big bad business. Profits over safety, profits over people. That combines with the families and the people. They care more about money than they do about me. And you know what? That's relatable to most of the people on your jury. Most of your people on your jury will have either been a tenant, are a tenant, work in an office space, live in a multifamily unit, have lived in a multifamily unit, and so they've dealt with that landlord. Think about it. We've all dealt with somebody that's dealing with a repair order, and they're saying, these people don't care about me. They don't. So what Rick talked about is the company witness caring about the residents as if it's their own. The plaintiff's theme is they didn't care about my residents. They didn't care about me. Every little bit of mold contributes to the injury and harm. That's that junk science that was talked about at length in April. But that's a plaintiff's theme. And we've seen that. We've seen this in cases where we get the plaintiff's lawyers have a group, a team of mold inspectors or mold evaluators or mold experts, and they will say one piece of mold in a home makes it uninhabitable. It's going to cause injury. You have to clean it and make it a sterile environment. But that's one of their themes. Every little bit counts. You'll hear sometimes, would you eat a moldy piece of cheese? We've heard those questions asked in depositions and at trial. Would you, sir, eat a moldy piece of bread? Would you, ma'am, eat a moldy piece of cheese? And that goes up against your defense witnesses. The landlord was the expert. That's where Rick talked about the policies and the rules and the experience. But a lot of times in the litigation, we see the landlord knew. They owned the property. They were the property managers of the property. They knew how the building was habitable, the residence was habitable, was it occupiable? They knew. They were the expert, not these poor tenants. The landlord ignored the policies and the rules. They didn't do what they said their policies said they were going to do. And I think it's important from the defense side of it. Plaintiffs and the residents know your policies inside and out. And they know it sometimes better than your own employees. So that's one where from a training side of things, you may want to think about making sure, like Rick talked about, making sure your employees are well trained on the policies and the rules. And then they ignored the industry standards. Now, what are the industry standards? That's a fluid question, but the plaintiffs will come up with that. That's part of that junk science we talk about. But they ignored the industry standards. The other themes is that the landlord knew the space was filled with toxic mold. It's always, you're going to hear toxic mold. That's the big theme. And they never disclosed it. Service requests, work orders were placed and they were ignored or never promptly responded to. They concealed and destroyed evidence. In other words, I submitted work orders. I made those requests. I talked to them. I sent text messages to the community manager, and where nothing ever happened. And where are those messages? So when Rick talks about the collection of documents, the plaintiff's lawyers don't really care about the collection of documents. They're saying, we know we submitted it, and now they're destroyed. So that's one thing from the plaintiff side. You're oftentimes fighting the negative, that you're proving up against the negative. And then again, they care more about making a profit than the people being harmed. So what other strategies, the claims? What claims are we seeing Brian asserted? Well, we see a breach of contract. They breached the lease agreement. They failed to provide a habitable home. Negligence, we see it as in the form of gross negligence, negligent misrepresentation, and negligence itself, that they failed to repair the residence. They failed to repair and remedy the issue at harm, and so they were negligent in their repairs. They may have shown up and they came onto the property and supposedly repaired it, but they didn't do it to actually be repaired. Rick talked about nuisance. We see that oftentimes where they say that they refuse to maintain or repair the residence or the building, and they caused harm to the health and the peace of mind. We hear that a lot in the nuisance claims, peace of mind. Fraud and deceptive trade practices. And the deceptive trade practices claims they'll bring because there's attorney's fees associated with that oftentimes. But the fraud is that they lease the premises with the knowledge that this was defective. They leased it knowing that there was mold in it. They leased it knowing that there was water damages in that. They were deceptive in telling us the work order history of the facility, of the building. So they didn't disclose everything that they knew was wrong with it, and that you as the landowner knew, or the property manager knew what was really wrong, and you didn't share everything. The breach of warranty, habitability, that is often tied to some of the landlord-tenant statutes, and that goes to violations of different statutes in terms of, again, you knowingly and intentionally failed to repair the issue, and you allowed us to live in filth and squalor. And the unjust enrichment goes to the profit I paid in, or the money's paid in on the lease, that you leased this terrible place to me and you made money, and I should have all of that as restitution back. We see the Lead-Based Paint Hazard Reduction Act and the RICO claims less common now because that's triggering federal. It could trigger you into a federal court. And the plaintiffs' lawyers don't want to be in federal court. They want to avoid federal court as much as possible. And they're instead there. So we're not seeing as much, but there are still some claims. Strict liability, that is tied to different state statutes. But they're claiming, again, you knew, you were fraudulent, you were deceptive, and therefore you're strictly liable. The infliction of emotion and distress and the conspiracy theories are other claims that we see asserted sometimes. So in terms of how they're bringing the claims, if you're a plaintiff's lawyer, Rick noted this, like they don't want to bring the single plaintiff claims. This is the single family residences, the owner of a home or a tenant. You may see a commercial building where it's occupied by a sole tenant or a single employee, but they really want to focus on going to the aggregation of the claims. And that's looking at the multifamily residences, or you're dealing with the same builder or remodeler, or the same landlord or property management company, or where there's multiple tenants in the building, in a commercial building, or multiple employees involved. And that again is because it makes it look really, really bad in terms of how bad this landlord property manager was. The class claims, we are seeing them making attempts at it, but that's through the aggregation of the claims. And then, as Rick noted, we've been able to defeat it because you can show that there's differentiations of it, but you're seeing it where there's multiple employees or multiple plaintiffs and multiple residences. And then let's go to the emotion and the faulty science. Now, if I'm a plaintiff's lawyer, I'm saying, what science? I don't need to have science. Look how bad you are. And that's going to the reptile strategy. And that's where I'm focusing on, we've all lived in a house, or most of us have experienced renting or occupying a home. Most of us have experienced working in a building that we don't own. And so it's thinking more on the emotional side of things. This is how bad it is. They didn't care. It's really focusing on they didn't care. And it's really not focusing on the science. And so the science doesn't really matter from the plaintiff's lawyers. And we often see that where, and Rick and I have dealt with that, where they're not really deposing the science experts. They're going to skip that over. They don't care as much. They'll do some other arguments, but as this dramatization is, the defendant knew there was a risk and a corresponding danger. They ignored it. The rules. They ignored the rules. They took the risk. They put you in danger, the people in danger. They should have to pay for it by not playing by the rules. And you have the power to make this right. They're avoiding the science and they're focusing on the emotions, and they're just going to the jury and saying, look at how bad this is. And they're doing it through photographs, and they're doing it through their mold inspectors that are saying it has to be 0 mold in the house to be a safe and habitable home. So they're focusing on the X factor. That's the really ugly pictures, and you'll see a lot of those pictures. And we've dealt with that, where they're focusing on how much bad mold, black mold, toxic mold. Those are the words you're going to hear. They talk about uninhabitable living conditions. Like, it's so bad that they had to move out and get an apartment, or they had to go move out and they had to live in a hotel. Rick and I have heard that so many times. It's so uninhabitable that they left the residence to go live in a hotel. And then when we look at the hotels that they're living in, it's just as gross, if not grosser. But they're playing on the emotions. They're talking about the marriage issues. They're talking about missing work. They're worrying about their children. Again, there's that peace of mind piece of it, that I had fear and anxiety. It's not tethered to science. It's not tethered to real science. But they do have their team of mold inspectors, and they have their team of mold experts. And we know who those are. And you have to really work towards debunking them and deposing them to break it down to actual science. But you'll hear claims like the mold exposure caused their medical conditions like autism, developmental delays, death. We had one with suicidal and murder ideations, infertility issues, chronic fatigue, brain fog, those type of issues that you're going to hear. They don't really care about the science at all. Instead, again, it's on the emotions. So our next poll question is, do you fear the reptile? A for yes, B for no, and C, none of the above. So let's just take a moment for you to do that poll question. Okay. Thank you for everyone who responded. So most of you don't fear the reptile, and that's because you're defense attorneys, I would say. But we also know that you have the ability to fight it with real, actual science. Some of you said yes, and some of you said none of the above. So I agree with the no's, and I think Rick would say the same thing, that we can fight the reptile, but it's something you do have to deal with. Depositions. I would say that this is one of the most challenging things from the defense side in taking the plaintiff's deposition. It's often unverifiable statements, and that is the challenge. I submitted the work order, and now it's missing. The repair person, I had this happen in a deposition. The repair person, not an employee, told me that that the property management company, they should never have rented this unit to us, and that there is black mold or toxic mold. So we often hear unverifiable statements. They don't have any witnesses. They can't tell you who it is. It's lacking in accuracy. It's lacking in timelines. It's lacking in issues. But they say that they have video recordings. They have ring bell recordings, whatever your home security recordings are. They'll tell us that they recorded it, that we submitted this work order and nobody ever showed up. My home security systems show that never happened. Okay, well, in the deposition, I'll ask the question, well, do you have those video recordings? No, those are no longer exist. It's been recorded over. And so you're oftentimes proving a negative. And the depositions, like Rick said, these are emotional people, and you also don't want to come off. They're already accusing you as a property management company or the landlord or their owner of being the big bad company. So you have to be really gentle in those depositions in terms of how you're deposing those plaintiffs. But you just have to keep asking, okay, do you have any documents that support this? Do you have any witnesses? And you have to keep trying to say, let me get back down to that timeline and let's break that down. But they're really challenging depositions. And you'll also hear how they did home testing. And they ordered a home test on Amazon, and they did their own home test, and the house was filled with toxic mold. And then you ask for the home test results and all of that. They don't have it. So those are challenging depositions. The other thing is they will often try to depose, the plaintiff's lawyers will try to depose your corporate executives. And they're going to want to depose, and Rick and I have dealt with this many times, where they're going to want to see the CEO or the CFO be deposed. And it's more just for an embarrassment and to make them, the big bad company, look so big bad, because the CEO and the CFO doesn't know that individual, do not know that individual tenant. And so they're trying to make those individuals and the company look bad because they don't, that's that theme going again, they don't care. So from the defense side of things, you should be focusing on the apex doctrine, and that protects those executives from being deposed where they have no personal knowledge. And you can go to the court and seek some type of safe harbor of having those executives involved. And we talk a little bit about what that apex doctrine is. And it's really, they have to demonstrate, the burden is on the deposing party to demonstrate that executive is the only one that has that unique and personal knowledge that you can't get from any other source. And then those depositions have to be, there's got to be protections placed around that deposition to minimize the inconvenience. So it's really an onus placed on the plaintiff's lawyer, but we often see it where they want to depose the president and the CEO and the CFO, or the head of safety. And so it's just to make the company look bad. And so damages. You heard Rick talk a little bit about it. They're unanchored damages, but their strategies are they were forced to live in an uninhabitable home because of the lease, or that they couldn't break the lease because it would have been too expensive. They were going to be punished by it, or they couldn't afford to break the lease because it would have required them to move out. And so they just were forced to stay there. We've seen a lot of times where they just lost their wages or had promotional opportunities taken away from them because they were dealing with all the maintenance and issues that were taking place, and the company couldn't be trusted. So I had to be there for all the repairs. All of the household items had to be replaced and repaired. So those all had to be shipped off, and we got rid of all of them. And you will see some of the mold experts tell them, and some of the mold inspectors tell them, you got to get rid of all your household items. And so they all need to be replaced. Our animals were hard. Rick and I had two families that accused one of our clients that they lost animals and died because of living in the home. It had nothing to do with that they were 14 and 20 years old. It had to do with living in the home. Other unanchored damages are the medical conditions they suffered as a result of living or working in the building. And, again, some of those are brain fog, memory loss, respiratory illnesses, and then the behavioral issues and the things like that. Their emotional damages, they're stressed out, their anxiety, their fear, they're fearing that their children are going to die because of living there. Their marriage issues. We have been blamed for many divorces and affairs, remarkably. I had one deposition where not only did the property management company get blamed for the ultimate demise of their marriage, but also for the man having multiple affairs, and then behavioral issues. So those are the damages that you'll often see asserted. And so with that, we have 4 minutes left. And how do we resolve this, Rick? So one of the things Rick and I will talk a little bit about is that resolving the case, Rick talked about this, that we need to get to the, oftentimes you're looking at early settlement and trying to get it resolved. And those are the damages and the document collection. But Rick, I think it's fair to say you got to choose the right mediator and try to see if we can get into an early settlement. Absolutely critical. Yeah. And choosing the right mediator is someone who you got to work with the plaintiff's lawyer and choosing that right mediator. And sometimes you defer to that plaintiff's lawyer and who should be the mediator. It really, a lot of times, this is one where you get to know your plaintiff's attorney and you say, tell me about your plaintiffs. How are they? And then you can work to choose the right mediator. But choosing the right mediator also means that they have an ability to understand the science behind it when we talk from the defense side of things. Rick, do you want to touch base real quickly on working with your insurer before the mediation? Yes, it's absolutely crucial for your defense team and the insurance team to coordinate on the approach to the mediation, the reserve that's in place, and what is going to be done at the mediation. It becomes very tricky when you have multiple insurers or you have reservation of rights issues. It's important to work with the client and with the insurers through those issues before you get to the mediation, or you're going to have a very difficult mediation if it turns out that one of the insurers isn't committed to resolving the case and the allocation that have been discussed. And then dealing with the judge and the arbiter. So if you're in an arbitration, one of the things I think we would say is definitely research either the judge or the arbiter and making sure we know everything about that judge and arbiter and how they lean towards personal injury cases and how they lean towards science and experts. And any relationship they may have with your opponents. And any relationship with your opponents. Great point. And then Rick, dealing with the jury. It's absolutely critical in a trial situation to make sure that you pick the jury and you're very careful in your questioning of the jury to select the right jurors, making sure you're going to have open-minded people who are not going to buy into the thematic sound bites of the plaintiffs, but hopefully will buy into your sound bites. We want folks who have some basic understanding of science and will agree that science is important, and making sure that we have those type of people on the jury. It's critical that we select people who can understand and address the scientific issues and understand those concepts, but it's on our experts and on the lawyers to explain those concepts in terms, dose, response, causation in ways that are understandable. And with that, I think we're nearing the end. We realize we have 1 minute left. So if there's any questions, we will be sure to answer them. Feel free to email either Rick or me or both, and we will make sure we get back to you. We had one good question about permissible exposure limits for indoor mold that you responded to. Maybe you could share that. Yeah, one real quick question was, are there any, in California, there's no permissible exposure levels for indoor mold? And the answer is, and the question was, are other states, have they actually developed PELs, permissible exposure levels? And the answer is neither the federal government nor any state has developed PELs for indoor mold exposure. And I think with that, I think we're wrapped up, folks. We have 3 more contaminated building CLEs. We have, as Rick mentioned, fact and expert witnesses in August, preparing for and managing government investigations in October, and insurance coverage issues, which are never boring, in December. So we thank you all for attending.
Thanks so much.